Hello and welcome. This is AdvancingMentalHealth.org's video channel. I'm Jeff Baker. This is a two-part series on the legal aspects of forced psychiatry. It features Gary Brown. Gary's an attorney who for over 30 years has dedicated his practice to representing people who have been captured, put into a psychiatric hospital against their will, and want to be released. In this part 2, Gary talks about the legal steps that need to be followed in order to forcibly treat someone. And then he'll compare those required steps with what actually happens at most psychiatric hospitals. If you haven't already watched part 1, where Gary talked about the need to change the way we look at forced psychiatric treatment, we encourage you to do so. Gary Brown's experience in this area provides us with a seasoned legal perspective on forced psychiatry that few people can offer. We encourage you to watch both parts to get the full picture. Here is Gary Brown, part 2.
Let's keep in mind that under the mental systems, and notice I don't use the word health, and there's an exact reason why I won't, but under the mental systems, people are captured and taken to a hospital. Now, it's very important that we stop and consider the legal significance of a hospital and the legal significance of physicians. The person who's a physician at the hospital in California has to be trained to be able to perform the function of evaluating the person who arrived. They're called active evaluators. And there's a whole training course in LA County, and they have to process that training and get a high enough score, and they have to sign in writing a promise to obey the law. And they have to agree that they're applying the law when they evaluate somebody who's arriving at the hospital. And they're terribly confused. They think they're being psychiatrists and evaluating a person's state of mind, when in actuality, they have to do the first element is determine whether one of the 3 legal characteristics is present. Are they suicidal? Are they homicidal, if I can use that term, harming others? Not necessarily homicide, but serious threat of harming others. Or are they gravely disabled? And these physicians, psychiatrists, skip over that like it doesn't exist, and yet they're required to think it through. Then they're supposed to think through whether the person's state of mind, which was determined by the person bringing them in to be bizarre, is actually a situation that can be addressed at the hospital in a constructive fashion.
I have a question relative to that. Now, typically, when somebody is brought to the hospital, do the people who make these determinations, do they even think in terms that you're talking about, or they just assume that that person was brought in because they were mentally ill and they need to be locked up?
Yeah, you've hit on it. Here's the most common error that occurs, and it is a legal error, and it's a big one. Somebody brings a person to the hospital door. I refer to it as the front door. And they have an application. And if you look at the application, it has a very small space to fill in the details of the reason why. Mm-hmm. But the county makes it clear that you're supposed to clearly articulate exactly what happened to give rise to capturing the person and bringing them to the front door of the hospital. And we have to keep in mind that the person who does that job might be a trained police officer, but nonetheless, they're not a mental health specialist. It might be a nurse who does have training in mental areas, but they're a nurse. It might be a psychologist working on a team with the police. It might even be a psychiatrist, but most often it's not. It's going to be a police officer or a social worker, filling in a form with very little space to tell their story. And the first step that the law requires, and it's made clear in the training manual, is that the physician, the psychiatrist at the front door of the hospital, acting on behalf of the hospital, is supposed to read the form and decide whether it has the right components expressed in it. In other words, is it sufficient? And if the form isn't sufficient, they're supposed to go, no, I can't talk to this person. And that is the first serious error that occurs commonly, is the form is insufficient. Let's assume for a moment the form isn't insufficient, because a reasonable police officer working in the field, hearing a person say something like, I want to kill myself, not being able to reason through whether they have a plan, whether they have access to the implements, and so forth, says, look, I don't want to take a chance. I'd rather take him to a professional. So we grant the police officer some latitude. We say, look, they get an exemption, what we call an immunity, for acting reasonably in their capacity. But now they're at the front door of the hospital with people who are supposed to be the experts in the field. And they're supposed to initially look at the form, and then immediately after looking at the form, do a preliminary interview. Well, what's a preliminary interview? They have a conversation. Mm-hmm. And in that conversation, the person is likely to say, you know, I was just kidding. Oh, really? But they skip that conversation. And here's why. They somehow come up with the wrong idea that because the person was brought to the door by a policeman or a social worker, I don't have to do anything except take them in, we lock them up, and we begin to treat them as a patient. And that is illegal and very common, a very, very common error. I mean, of the hundreds and hundreds of people I've dealt with over 30 years, I would say that's the most common error that has occurred.
So people just at the hospital, they assume that it's justifiable that this person be locked up because the policeman brought them. Yeah, so they must be...
They actually mistakenly think it's required. That's how bad the error is. Okay. And it's legally not required. It's quite the contrary. There's supposed to be an independent review of the form and determination that the basic elements are in the form. And then once the form is deemed adequate, that's the probable cause standard in the law, then they can let them in the front door, so to speak. Obviously, this can happen inside the lobby of a hospital, but I think of it as the front door, and then inside a locked room, they then have to do an interview. And that interview is a preliminary step. It's not an in-depth evaluation of the person's state of mind, but more to learn whether this person belongs here, because they have a second option. They can decide that the person that they're talking to could be handled better at a community facility. And the statute says that they can make a decision to divert them to a community facility. And they skip that step very, very often. Okay? And they go right to the third step, which is to evaluate the person, and that is typically done by a social worker rather than a psychiatrist. Now that takes a moment to explain. The statute itself talks about different kinds of evaluations that have to occur. And a very important one is the context of understanding who the person is. So they have to get their history, and that includes their family ties and their job, if any, and their friends, and whether they have a history in psychiatry with issues, and any other things, and whether they have job skills, whether they have educational skills. and so forth. And the point is, that is done from a check sheet, done by somebody from the social sciences, social welfare, not by the psychiatrist. And you will often see that, as I've reviewed hundreds of these, there are check marks on them, which doesn't convince me at all that any in-depth conversation occurred. It doesn't help me believe, and my interviews with people show to the contrary, that any meaningful relationship was established. How can you have a conversation with somebody about so many important parts of your life if you don't feel comfortable, if you don't trust them? How are they going to learn all these important things if you're not willing to talk to them and they don't really care? If we go back in the literature of psychiatry, let me give you a little slice of history. You'll see where I'm coming from. When we were having debates about if and when a psychiatrist should reveal to police authorities that they're treating a person who's dangerous, we ran into some very reasonable disagreement. Number one, the psychiatrist would say, hey, I'm a physician, and there's a physician-patient privilege in the evidence code. I'm speaking from California, but you'll find it all over the nation and federal. And I can't tell a secret when my patient tells me something. I can't go tell anybody else. And they were right. And the second thing, and this is the one that really mattered, when a bunch of lawyers were seeking to sue them in the civil courts for the harm that was caused by their patients, whether it be a murder or a rape, and they were trying to hold the psychiatrist responsible for not having handled the situation by revealing it to police authorities, articles started getting written. And the articles said, putting it simply, we can't predict behavior based upon what people are telling us. We can't be sure. Now, I'm going to elaborate this thought by going to another parallel subject. For years and years, the field of psychology has been trying to create the impression that they can be helpful in the criminal process. Now, we wonder oftentimes when somebody has committed a crime, what to do with them. How do we help them? Are these the kind of people that should be locked up for a long time or given a second chance or whatever? And so psychologists developed what they said were tests to determine whether people were likely to be antisocial, in other words, criminal in their nature. And one psychologist, and I'm leaving names out on purpose, I'm not here to pick on people, made himself famous by coming up with a test that was used in the courts a lot. And I looked at the test, and half of the criteria points were based upon childhood events. Whether the person was brought up in a home where the parents divorced, whether the child had a juvenile record. And I looked at it and I said, this idea that we know a person's future behavior because they had a rough childhood is beyond statistically proven. It's a theory that I don't happen to find validated, and many other people don't find validated, and certainly we shouldn't be using it by the government to impose consequences on people. That, to me, should be a very high standard of verification, of validation. In other words, we should be very confident that something is true before we begin to infringe upon persons' liberty, upon their ability to be whoever they are, whether we like them or not. And so this test about antisocial behavior has less credence now. But for a long time, it was testified to in court. And you'd shake your head, and judges would agree with it because it was being spoken about by PhD psychologists and psychiatrists and so forth, whom they had to turn to as the experts because nobody else had the credentials and nobody else disagreed. You see? So we're in a quagmire when it comes to this field because we're making assumptions that we know things that we don't know. And that's why I don't want the government using its might to force people into systems, and we haven't even gotten into what happens when you force them into the system. I'm saying stand down, government. This has to either be voluntary or it's not going to exist.
Thanks for watching. If you like our content, subscribe. We'll keep you posted as we add new videos. Here at advancingmentalhealth.org, we only have one purpose, and that is to supply information and resources that can help produce better outcomes. Thanks. We'll see you next time.